Case is Pickering versus Board of Education. This case was seen in the Supreme Court of the United States in 1968. The facts are that Marvin Pickering, a school teacher, wrote a letter to the editor at the Lockport Herald complaining about a recently defeated school board proposal to increase school taxes. The letter complained about the board's handling of past proposals and allocation of funds, favoring athletics over academics. The school board felt the letter was detrimental to the efficient operation and administration of the schools and opted to terminate Pickering's employment. Pickering sued in the Circuit Court of Will County alleging his letter was speech protected under the First Amendment. The court ruled in favor of the school board and the Supreme Court of Illinois affirmed. The issue with this was Pickering's letter constitutionally protected by free speech. Holding, teachers have constitutional right to speak out freely on matters of public concern. The legal rationale, the court holds that truthful statements by a school teacher critical of the school board are within the ambit of the First Amendment. So also are false statements innocently or negligently made. The state may not fire the teacher for making either unless there are special circumstances not present in this case demonstrating an overriding state interest, such as the need for confidentiality or the special obligations which a teacher in a particular position may owe to his superiors. These can be seen on page 837 on the second column. I'm reading the second paragraph where it says, "What we do have before us is a case in which a teacher has made erroneous public statements upon issues then currently the subject of public attention, which are critical of his ultimate employer, but which are neither shown nor can be presumed to have in any way either impeded the teacher's proper performance of his daily duties in the classroom or to have interfered with the regular operation of the schools generally. In these circumstances, we conclude that the interest of the school administration in limiting teachers' opportunities to contribute to public debate is not significantly greater than its interest in limiting a similar contribution by any member of the general public. The public interest in having free and unhindered debate on matters of public importance, the core value of the free speech clause of the First Amendment, is so great that it has been held that a state cannot authorize the recovery of damages by a public official for defamatory statements directed at him except when such statements are shown to have been made either with knowledge of their falsity or with reckless disregard for their truth or falsity. It is therefore perfectly clear that where appellant, a member of the general public, the state's power to afford the appellee board of education or its members any legal right to sue him for writing the letter at issue here would be limited by the requirement that the letter be judged by the standard laid down in New York Times.